move now to our second panelist, Professor Juan Rodríguez Delgado, who will familiarize us with several issues of the judicial sale, but I believe that his core argument will relate to the conditions for domestic judicial sale to have international effects under the prerequisites of the draft instrument. Professor Delgado, the floor is yours.
Yeah, thank you very much. Good morning, everyone. I would like to express my gratitude to Igor and the International Maritime and Transport Law course. Well, after the presentation of Anne Fenech, I'm going to explain what are the conditions for a judicial sale of ships to have international effects and the scope of the UNCITRAL draft instrument. Well, this is the agenda for the next minutes, but I'm going to skip some part of the presentation because Anne Fenech has mentioned very well, better than mine, of course, because she is the most important participant on the working group session because she is the CMI representative represents in the UNCITRAL, and as well, of course, Petra is one of the most active delegates in the discussions. So just for a recap, what is a judicial sale of ships and which are the problems related to the sale? So, as I said, in some matter of recap, I'm going to explain briefly what is a judicial sale of ship and which are the problems related to sale. I say it's a recap because Anne Fenech obviously has explained this in detail. Just as a normal situation in which a ship owned by a company, normally, for example, in this case, under a Spanish flag, contact with the bank, so in order to proceed with that acquisition. So the bank is the creditor and the owner is the debtor of obviously of the credit, but during the life of the ship has many other credits related to the ship, such as employment contracts, bunkering, supplier, other kind of suppliers, port dues, pilotage operations, salvage awards, ship repairs, ship agents, fees, etc. One day, imagine the situation in which the owner enters into default with the bank, with the mortgagee, and the bank go to the court, imagine a Canadian court, in order to obtain a favorable judgment for that credit. The court is going to arrest, under the domestic law of Canadian, is going to arrest the ship, and if the owner remains in default and not honor the judgment, then the creditor needs to enforce his judgment against the ship. And this leads to a judicial sale for the creditor can get paid. So at the end of the day, we have a judicial sale, or by public auction or private treaty, depending on the jurisdictions. And in this judicial sale appear a new participant on the market is the new purchaser. The purchaser is going again to contact with another bank in order to enter into a mortgage agreement for financing this operation. Well, with the distribution of the price of the sale, it's going to be paid the first bank, the mortgagee, and other notified creditors involved in the judicial sale. But the problem is, has the new purchaser a clean title over the ship? So is this ship free and free and clear of all existing encumbrances, such as maritime liens, such as mortgages, such as creditors, such as encumbrances, charges, etc. And the question is important for two reasons. The first one is because the buyer needs to know that the ship can be disregistered from its old flag and registered under new ownership in a new flag without any problems. Okay, in this case, remember the flag of the ship was a Spanish flag. So the new purchaser must go to the Spanish registry in order to cancel previous mortgages and charge and change the ownership of the ship. And if you want to deregister the previous flag and register the ship in another nationality in a new flag. So in this first stage, we have problems of international recognition, because what's happened if the Spanish registrar does not recognize the foreign judgment, the judgment from Canada, the judicial sale judgment. So we have a problem, because if the Spanish registrar does not recognize the certificate of the sale, is not going to deregister the ship. Well, but now put this first problem aside and go to the second problem. Imagine this ship sailing around the world, worldwide, and one day in a Japanese port, one of the lien holders, remember our first lien holders of the ship, go to the court and request the arrest of the ship for a previous charge, for a previous liens. Obviously, the purchaser is going to surrender the court the title of the judicial sale, the clean title, saying, oh, no, I acquired the vessel free of all existing charges and encumbrances. So the court has two different alternatives. Might recognize the effect of a foreign judicial sale, or might not recognize the clean title effect of a foreign judicial sale. So again, we have problems of international recognition. If the court might not recognize the clean title effect of a foreign judicial sale, it's going to proceed with the arrest of the ship, and so we will have a new action against the ship. What are the negative consequences of this? There will be purchaser in judicial sales, prices go down because no one's risk. Banks aren't going to lend money for the owners or the new purchasers, or even lending money with higher interest. So at the end of the day, legal, as Anthony said, legal uncertainty. If the court recognizes the effect of foreign judicial sale, what will be the consequence? Release of the ship. The lien holder has no action in rem but maintain the action in persona against the owner of the ship, and high prices and more offers in the judicial sale. So at the end of the day, legal certainty in the shipping and the financing sector. So that's the reason, and obviously in my opinion, that we need a convention on recognition on judicial, not recognition on judicial sales, recognition on the effect of the judicial sale of a ship. Okay, I'm not going to enter the background and structure of the draft instrument because Anthony has mentioned all of the details of the Travax preparatories of the instrument. Just an update for the draft instrument. I'm going to compare very briefly the Beijing text presented by the CMI and the current working paper 92, the fourth revision of the instrument. So just, I'm not going to enter into detail, obviously, just for compare. In the Beijing draft, we had 22 definitions. The working paper, the current paper, we have 12 definitions. So compare the different definition of the different texts. Regarding the scope of application, it's quite similar, the text on the Beijing draft and the current working paper 92, with obviously with differences, but with many many coincidences. Regarding the notification process, you can see both columns with the different text. Oh, this is important certificate, because look at this. The Beijing draft is just a half of the slides, and the current Article 5 is almost two times. This is an evidence of the importance of the certificates in the current instruments. And regarding the effects, you can compare both texts, articles, especially Articles 6, 7, and 8, and Article 6 that now in the current text is very reduced from the original Article 6. This is the work in progress in numbers. So the scope of application, the Beijing draft in blue and the working paper 92 in green, the Beijing draft in blue. So this is the number of words of the article. So the number of words, the scope of application is quite similar. As I said, the notification process, well, again, quite similar, but the certificate, you can look the difference between the Beijing instrument and the working paper 82. So in the current Article 5 and Article 5b, the text has more than 500 words. In the Beijing text, the certificate occupied only 250 words. Okay, so the conclusion of this work in progress in numbers. First, the increase of the importance of the certificate in the judicial sale process, increasing the importance of the effect of the judicial sale in the contracting states, consider a reduction on the number of definitions, as I said, and reduction of the importance on the notification process in the convention. So look at this, the changes from the working paper 90 to the working paper 92. This is the differences between the current instrument and the previous one, the working paper 90, is the differences are not considerable, and that means that we are in the last stage of the instrument. That means the working progress of the working paper is becoming at the end of the stage of the production. Okay, now I'm going to enter into the conditions for a judicial sale of ships conducted in a contracting state to have international effect under the scope of the instrument. The first one is the sale must be ordered by a court in a contracting state. The second one, the sale has been conducted under the law of the state of the judicial sale. The third one, the ship was sold in accordance with the notice requirements. The fourth one, the ship must be at the time of the sale physically within the territory of the state of the judicial sale. Next one, the proceeds of the sale are made available to the creditors in accordance with the law of the state of the judicial sale. And lastly, the judicial sale must confer clean title to the ship on the purchaser. Regarding the first one, it's not very complicated. Just the judicial sale must be ordered, approved, or confirmed. That at the end of the day is the judicial sale must be conducted by a court in a contracting state, just by way of public auction or private treaty. Regarding the private treaty, the working group considered that this private treaty is not a private sale, okay, but rather a sale carried out under the authority of a court. Some delegations have suggested to define the term authority, but the term is not nowadays undefined by the text. And in the previous definition of this first condition, existed another requirement or another possibility, is by way of by any other way provided by the law of the state of the judicial sale. By this reference, the third one was deleted from the current text. The second condition, the sale has been conducted under the law of the state of the judicial sale. I'm not going to enter because of Anne Fenech has mentioned this in deep. The ship was sold in accordance with the notice requirement. This is the third condition. Then the Article 4 related to the notice requirements established the person that must be notified by the court previous to the sale, formal requirements and content of this notification, and exists in the Annex number 1 a form for this kind of notifications. What different views were expressed during the 38th session on the operation of the notice requirement to function. Someone consider the notification process as a state-alone requirement that apply to all judicial sales, and other delegations consider the judicial sale as a condition for the recognition regime. Well, the prevailing view in the working group was that the notice requirement did not serve as a standalone requirement, but needed to be read together with Article 5. And this is the reason that this provision, the ship was sold in accordance with the notice requirement, has been removed from the Article 5 and passed, has been removed from the Article 6 and passed to the chapter of Article 5. The fourth one is the ship must be at the time of the sale physically within the territory of the state of judicial sale. In the previous version of the instrument, the term territory was, in the current text, the word jurisdiction has been replaced for the term territory, because the term jurisdiction might cause several problems, because all of you know that when the ship is on the high seas, is under the jurisdiction of the state of the flag. But in that case, the ship is not under the real jurisdiction. I mean, do you understand me? It's not under the physical jurisdiction in order to, for example, to arrest the ship or in order to sail the ship. So the word jurisdiction was replaced by the term territory in this current text. Has been some discussion on what kind of ships are covered by this convention, if seagoing ships are covered, or if inland navigation ships are covered under the convention, or only seagoing ships. The majority of the delegation supported retaining the Article 14.2, in which, or ensuring that the state parties to maintain the rights regarding to the 1965 Convention and the Protocol number 2 concerning attachment and for sale of inland navigation vessels. The definition of a ship in the Convention is any ship or other vessel registered in a registry that might be the subject of an arrest or other similar measures capable of leading to a judicial sale under the law of the state of judicial sale. So this is a broad definition, a very wide definition, and in this definition I include pleasure craft, ships under construction, or inland navigation ships, as I mentioned before. Regarding the time of the judicial sale, exists a discussion what does mean time of a judicial sale, because a judicial sale is a process. So must the ship be in the territory of the state at the beginning of the process, during the process, or at the final stage of the process? Because normally a judicial sale makes some time. It's not just like an arrest that is very boom in a moment. The judicial process spends some time. So what does it mean physically within the territory at the time of the sale? So some delegations say, oh, from the start to the end of the judicial sale. Other views is no, only at the end of the procedure of the sale. During the last revision, general agreement, under my view, in the working group, that the ship is physically located within the territory of the state of judicial sale at the final stage of the sale. Well, the fifth requirement is the judicial sale confers clean title to the ship on the purchaser, and this is important. The purpose of the instrument is not recognize a judgment of a judicial sale in another state, but rather the international effects of a judicial sale conducted in a state party. Obviously, as long as the sale produced an absolute clean title, as Anne mentioned before, an absolute clean title on the ship to the purchaser. So I see this condition as a mirror, the convention as a mirror in which the judicial sale carried out in a contracting state must look. If the reflection of this mirror, if the reflection of time is the same, then the judicial sale, so when I say the reflection obtained is the same, that is, if there is an usual coincidence in the total period of credit. So if the judicial sale conducted under the law of the state of the sale confers an absolute clean title, so if the reflection obtained is the same, that judicial sale shall be able to expand its international effect in another contracting state once the certificate has been issued. However, if the reflection obtained is not the same, so the judicial sale carried out under the law of the state of the sale, but for any reason that sale does not grant a total period of credit as provided by the convention, then that judicial sale, despite being valid, legal, and effective in the state of the sale, shall not be able to expand its effect internationally based on the convention. Okay. And the last part of my presentation is regarding the Bareboat Charter and judicial sale of ships. Because, well, in Spain we have a problem with this. Okay. Today, probably in 1 year, not. I'm going to explain why. So the question is, might the Bareboat Charter be considered as a right or a claim under the clean title effect of the convention? Or on the contrary, we are dealing with a contract that survives even in private and judicial sales? So is the Bareboat Charter, so does the Bareboat Charter survive to the sale, to the judicial sale, or not? Is the purchaser bounded in some jurisdictions to honor the existing Bareboat Charter, or might invoke the convention and request to the state where the judicial sale has been conducted a certificate that confirms its a clean title, including a Bareboat Charter? Both questions are interesting questions because many of the ships obviously are under a Bareboat Charter agreement. Well, the working group vision is based on the fact that the Bareboat Charter is terminated with the judicial sale. However, in some jurisdictions, the judicial sale does not extinguish the contractual relationship between the shipowner and the charter. So the Bareboat Charter shall continue existing, and therefore that sale shall not be under the convention effect, because for the convention, this sale has not granted an absolute clean title over the ship, because the new purchaser has to honor, has to maintain the contractual relationship with the charter. Okay.
Does it have to be Bareboat or any charter?
Or any charter. Okay. Well, in some jurisdictions, I don't know in Croatia, but during the working group session, for example, I remember Professor in Japan, I don't know, Tomotaka, and I don't know if in Germany as well, yeah, but obviously in Spain, the right of Bareboat Charter survives a judicial sale. Obviously, in other legal systems, probably in common law systems or in many other jurisdictions, even civil law systems, the Bareboat Charter might be considered as a right or a right of use of the vessel, which is clear, which is extinguished with the judicial sale, awarding the purchaser a ship free of any charge. Why I say in Spain? Because in Spain, we have an article in our Maritime Navigation Act that reads the following. Even in the event of disposal of the ship, and the problem is the word disposal, but disposal is in this term is used, the same term is used in the provisions on judicial sales. So in the event of disposal of the ship, under my opinion, by virtue of a legal transaction in which ships include judicial sale, the purchaser shall be subrogated in the existing Bareboat Charter, as long as this register or its existence is effectively known at the moment of the sale. So consequently, in Spain, the Bareboat Charter shall not be extinguished with the judicial sale, despite the contractual clauses might despite the contractual clauses, because normally in a Bareboat agreement, clause 25 says not refers directly to the judicial sale, but refers to any change on the disposal of the ship, terminate the contract. Okay. However, and this is so if in Spain, for example, if the Bareboat charter is not extinguished with the sale conducted in Spain is not a clean title sale under the view of the convention. However, and as a result of the negotiation in the working group number 6, the Spanish Association of Maritime Law has submitted a proposal to amend that article in order to make a new addition on this article. And the new addition is this regime regarding the disposal of the ship and the fact that the purchaser shall be subrogated in the existing Bareboat charter. This regime shall not be applicable in case of a judicial sale of ships, obviously. Now it's clear. In which cases the contract shall be terminated without prejudice to the right that might correspond to the charter against the owner. Okay, so with this new addition that is in process, for now it's an amendment, but in Spain now we are in a process to amend the maritime legislation. So we are introducing different amendments. For example, and this is curious, we are going to introduce an article on unmanned ships. That is okay. I don't know if it's the moment to introduce an article on unmanned ships, but we are going to introduce an article. Probably we're going to be the first. I don't know, but I'm going to be the first legislation. Oh, Croatia, do you have an article on unmanned ships? Okay, so the second one. Spain never is the first. We're going to use an article on unmanned ships.
But only definition, nothing.
Okay. No, in Spain it's quite similar, just definition and something related to the safety conditions.
If I may, can I ask?
Yeah, sure.
But I think in reality what happens is that the charters, especially bareboat charters, are not going to sit passively, looking at the bank, going to arrest the vessels, go to the court for a sale. They're not going to look at it passively, they're going to go to the court to get an injunction against the bank. That happens. Because by doing so, the bank is interfering in the business of the charter. And they go to the court for injunction to prevent the bank doing exactly that. On what basis? Not contractual, because there is no contract between the bank and the charter at all, but on the basis of tort. Because the bank is doing damages to the charter by protecting their own interests. So it can go into very, very complicated messy situation. Because we have very, very big companies chartering that vessel.
Yeah. So that's with this addition in Spain, because some academics in Spain or some lawyers says that the spirit of the law in Spain is not the spirit of the law in Spain probably is not to permit the subrogation of the Bareboat charter after a judicial sale. Probably this is not the spirit of the law, but this is the wording of the law. If I read the article, in the event of disposal of the ship, and remember the word disposal is used the same term in the judicial sale, the purchaser shall be subrogated in the existing Bareboat charter. Probably the spirit of the law is to interpret only this article for private sales, not for judicial sales. But if as a lawyer, I'm going to interpret. If I'm the lawyer, obviously for the Bareboat charter, if I'm being the Bareboat charter, I'm interested in to maintain the contract. If I'm not interested to maintain the contract, terminated. That's it.
Yes.
Obviously, but if I'm the Bareboat Charter lawyer, I'm going probably, I don't know probably, but I can have interest on the continuing of the Bareboat Charter because probably it's in a time charter agreement or a void charter agreement, so it's a bit complicated. But with this provision, with this new addition, Spain will be, from that moment, if this addition succeeds, among those states in which the judicial sale not only purge of all trades and encumbrances on the ship, but also extinguish bareboat contract, or because the law refers only to to bareboat charters, not to time charters or voyage charters. So now Spain will become a purchaser-friendly scenario in which to proceed with the judicial sale of ships. And well, the conclusion, just to finish, is the adoption of uniform rules to govern the recognition of judicial sale of ships shall promote harmonization in this topic, reduce legal obstacles, increase obviously the prices, because reducing legal obstacles, the prices will go up. Safeguard the interest of bona fide purchasers and improve the efficiency of such recognition. And that's it. Thank you very much.